Before analyzing an IPO valuation, investors need to know more than just the company's profits and debt. They also need to understand the legal matters surrounding the company. In this explainer, we're going through Indo-MIM's outstanding litigations and material developments exactly as disclosed in its DRHP. We're skipping the marketing spin and looking strictly at the legal facts.
Because honestly, there's a golden rule in due diligence. Before valuation comes liability. Think about it. A pending lawsuit, a massive tax demand, or an environmental compliance notice. These can severely impact a company's financial health and cash flows. We aren't here to make assumptions or predict how any of these cases will pan out. We're just here to unpack the disclosed realities.
Okay, so we'll be moving systematically through the core areas. We're covering the high-level litigation overview, tax proceedings, regulatory notices, creditor dues, recent material developments, and wrapping it all up with the key takeaways. Let's start right at Section 1, the litigation overview and the baseline facts.
Right out of the gate, what's really interesting here is this number. The DRHP reports an absolute zero for criminal proceedings. That's across the board for the company itself, its promoters, its directors, its key managerial personnel, and its subsidiaries. Zero outstanding criminal proceedings instituted against them and zero instituted by them. When you're evaluating IPO risks, a completely clean slate on criminal litigation is a fantastic foundational data point.
So where does the actual legal exposure sit? Well, the data shows that the litigation is heavily concentrated directly on the parent company. Indo-MIM Limited faces 33 tax proceedings and 5 statutory or regulatory proceedings. Meanwhile, the promoters and directors are named in just 2 regulatory matters. And even more notably, the subsidiaries show 0 reported material civil litigations, 0 tax proceedings, and 0 regulatory actions against them. The legal footprint is entirely localized to the main company.
Moving into Section 2, let's examine the material tax proceedings and the actual monetary exposure.
The DRHP discloses that the company currently faces 33 ongoing tax proceedings, aggregating to an exposure of 2,861.97 million rupees. That's roughly 2.86 billion rupees. It's definitely a substantial figure, but, in the world of IPO due diligence, a headline number like that only tells half the story. We really need to look at what makes up this number and, critically, the status of these demands.
The crucial nuance here is distinguishing between cases that are still pending and matters that have already been resolved. For instance, the DRHP details a pending matter involving 140.40 million rupees. This is related to a service tax issue from 2016, where authorities allege the company irregularly utilized SENVAT credit. The company has appealed this to the Customs, Excise, and Service Tax Appellate Tribunal, and it remains pending today. But on the flip side, the DRHP also details a massive 647.57 million rupee GST demand that has completely changed status.
Just listen to this timeline. In July 2024, a show cause notice was issued demanding that 647.57 million rupees for allegedly unpaid GST on a reverse charge mechanism. This was for services imported from their U.S. subsidiary, Indo-MIM Inc. The company argued that their subsidiary was merely an intermediary, meaning no tax was due. Well, by August 21, 2024, after a personal hearing, the Deputy Commissioner of Commercial Taxes passed an order dropping the entire tax demand. So while the aggregate exposure number sounds high at first, the company has documented proof of successfully defending and disposing of major claims.
Let's shift to Section 3, regulatory and statutory notices.
These matters don't always carry massive monetary figures immediately, but they represent vital operational realities. The company has 5 pending statutory matters. One is a very small employee state insurance corporation demand for just 0.11 million rupees, which the company claims was just an erroneously generated challan. More importantly, though, there are 2 unquantified notices from the Karnataka State Pollution Control Board, or KSCPB. These pending notices allege a failure to submit compliance records regarding mandatory emission control retrofitting for diesel generator sets at their Doddaballapura and Hoscote manufacturing units. The financial penalty isn't quantified, but failure to comply with environmental regulations could lead to unforeseen operational disruptions. The DRHP is very clear about noting that.
Now, stepping away from the company itself, the promoters and directors, including key managerial personnel, are distinctly named in 2 specific regulatory proceedings.
First, in August 2024, the Registrar of Companies issued a show cause notice for historical non-compliances regarding the appointment of a cost auditor and actually conducting a cost audit for the financial year 2024. Second, and this is strictly documented in the DRHP, the company, along with specific directors, filed a suo motu compounding application dated September 21, 2025. This was filed to address unspent corporate social responsibility, or CSR funds, that weren't transferred to the specified unspent CSR account within the required timeframe for the financial years 2021, 2022, and 2023. Filing suo motu basically means they initiated this proactively to settle the non-compliance on their own terms.
Next up, Section 4, looking at outstanding creditor dues and operational liabilities.
Shifting gears from legal disputes, we absolutely have to look at supply chain obligations. The DRHP provides a highly transparent snapshot of exactly who Indo-MIM owes money to as of March 31, 2025. The company owes a total of 2.966.92 million rupees spread across 1,947 creditors. Over 2.1 billion of that is owed to general other creditors. But pay close attention to the specific carve-outs. There are just two material creditors accounting for 314.14 million rupees. And most notably, the company owes 547.73 million rupees strictly to micro and small enterprises. Timely payment to MSEs is strictly regulated in India, so this is a critical liability metric for investors to keep an eye on.
All right, Section 5 covers recent material developments and post-balance sheet events. Due diligence doesn't just stop at the balance sheet date. We always have to look at material developments, those significant events that occurred after the reporting date but before the DRHP was finalized, because they can fundamentally affect the company's business footprint. As detailed in Note 53 of the financial annexures, the company evaluated events up through September 26, 2025. The absolute standout material development here is a major acquisition. In May 2025, Indo-MIM acquired a 100% equity stake in Phoenix Deventures II Inc., a company based in the USA.
The DHP notes that Phoenix Deventures is involved in medical device prototype manufacturing and design. What's crucial to understand here is the tone of the disclosure. The DHP presents this purely as a factual post-reporting strategic expansion. It does not forecast future revenues or make speculative promises about how profitable this acquisition will be. It simply states the facts. The corporate footprint has now expanded into U.S. medical device prototyping.
And finally, Section 6, summarizing the key investor takeaways. Pulling all these distinct threads together, what are the purely factual takeaways you need to remember? First, the baseline is strong. A clean criminal record across the board, and clean subsidiaries with no material litigation. The exposure is heavily ring-fenced to the parent company, which faces nearly 2.9 billion rupees in tax exposure across 33 cases. However, we've clearly seen that massive demands, like that 647 million rupee GST notice, have proven resolutable in the company's favor. On the regulatory front, there are pending unquantified environmental notices, plus historical compliance issues that are being proactively compounding. And operationally, they just secured a 100% acquisition in the U.S. medical device space.
But here is what you really need to keep in mind. Recognizing what the DRHP does not disclose, it strictly avoids filling gaps with assumptions. It does not guarantee that the company will win its 100 million rupees service tax appeal, and it does not attempt to quantify the potential financial impact or operational downtime that could theoretically arise from those pending state pollution control notices. It simply gives you the facts and leaves the ultimate risk assessment up to you.
Which leads us to the ultimate question for your own due diligence. Does the proposed IPO pricing accurately reflect these disclosed legal, tax, and operational realities? Litigation is only one part of IPO due diligence. The next major question is valuation. In the next episode, we'll examine the basis for offer price and understand how the DRHP supports the proposed IPO pricing. Thanks for joining me.